wrote about this topic last year in the American Lawyer. Actually, I think it was the July issue, just in case you want to rush out and get an issue. And actually, partially it was based on some conversations I had had with Craig Johnson about the subject, also some conversations I had with Tower Snow, who's the chairman of Beck, both of whom had raised this possibility, and it seemed like an intriguing idea. So I wrote an article basically just throwing out the idea as something that law firms should think about. And I wrote it from the perspective of urging law firms to think about it, not so much because I'm convinced it's a great idea for law firms, but I think law firms should be encouraged to think creatively and to think differently about how the profession can be structured, what their business model should be, and this just seemed like an interesting avenue to think about. Some of you might remember a couple years ago there was a fellow who wrote for our magazine named Steve Brill. He proposed the idea actually back in 1987 that law firms might think about going public. He later actually backtracked in 1996, decided, as he said, it would be a perfectly awful idea and would ruin the profession. So obviously there's a range of thinking on this issue, even coming from one person. What we're going to do tonight is I'm going to pose a few questions, get the discussion going. The topic of law firms going public raises a lot of questions. First of all, is it possible under the current rules? What are some of the ethical, professional considerations? How do you value a law firm? What would a law firm do with the money? Would anybody, does anybody want to buy the stock? Is this something that anybody would be interested in? So starting off, I'll introduce briefly the panelists here. At the far end, we have Professor Joseph Grundfest from Stanford Law School. He is the William Frank Professor of Law and Business at Stanford and also a former commissioner of the SEC. Next we have Joanne Garvey, a partner at Heller, Ehrman, White, and McAuliffe. She has studied a lot of the ethical and professional issues that might come up as a member, or actually as a governor of the ABA, and also she is the board's liaison to the multidisciplinary practice task force. And next we have Alan Austin, the managing partner of Wilson, Sonsini, Goodrich, and Rosati. And next, Craig Johnson, the founder and partner at Venture Law Group. So I will dive in. And first, what I'll do is just ask everyone very briefly to talk about why a law firm might want to go public, and on the other hand, why it might be a terrible idea for a law firm to go public. And just kind of briefly, we'll get into some of the details and more discuss in detail some things later. Maybe Craig, if you want to start.
When we started Venture Law Group in 1993, we actually structured the firm so that it could go public if the professional rules ever permitted it. We actually issued founder's stock to the founding lawyers of ELG so that we wouldn't, in theory, have those arguments if and when we had a chance to tap into the value of the enterprise. I've always been intrigued by the possibility of having more capital to do more things than law firms can traditionally do. In most cases, the firms are limited by capital. They distribute all of their profits to the partners every year. They spend very little on research and development. And I was very intrigued with the possibility of having more routine capital to do more innovative things that law firms traditionally don't do. On the other hand, I think that there are also huge disadvantages for law firms considering public ownership, the scrutiny of quarter-to-quarter analysis of earnings, the fact that the markets don't appear to value service businesses the way they would value other kinds of businesses. So on the whole, my scale still tips towards the negative, but we remain very intrigued. Alan?
Well, let's see. I used to think that we wouldn't have anything really to do with the money. A law firm isn't that capital intensive a business. in our case, we've grown very rapidly, continue to grow very rapidly. Landlords don't any longer pay for tenant improvements and so on. And so I suppose it would be kind of handy to have the money to build out space and improve technology and that sort of thing without having to withhold it from the partners. Although I was talking to a friend recently at one of the big 5 accounting firms, and he told me that their policy was that your capital in the firm was equal to 1 year's compensation. And wow, I guess if we did that, we'd have plenty of capital. We wouldn't need to think about other sources. That would be kind of painful, though. I think that obviously there are issues about being public and having to report and being subject to scrutiny and so on. I think the bigger you are, probably as a firm, the less frightening those things are. You're already covered in depth in the American Lawyer anyway, and your numbers are out there and so on. So you don't have the same kind of privacy that smaller firms do. But I look at the question of the long-term viability of the enterprise. I mean, there's no doubt that if you take the firm public, in Susan's article, she used the model of taking half the earnings and sort of devoting those to the public and keeping the other half to pay the partners. And then if you figure that you get 20, or in today's market even more, maybe 25, 30 times earnings, that's a big price that you potentially are yielding to the current partners of the firm, and probably you make them stay for 5 years or something to get it. But still, it's clearly a bonanza to the current partners of the firm. But then the question would be, what about going forward? I mean, how would you attract people to the firm in the future? And could you really persuade people that their stock options in the future are going to wind up being worth as much as the half of the profits that they're giving up in that model? And I question it. I mean, I think if you could, then obviously the vesting that would be entailed from top to bottom in the organization, secretary, associates, and partners could be a great thing in terms of retaining people. But I have real concerns about whether in the long run you'd wind up killing the enterprise rather than really helping it. Because after all, we are not a high-tech company. You know, we represent high-tech companies, but we're not a high-tech company. And that, I guess, goes to Craig's point about what kind of valuation do you really get for a service business. Anyway, Joanne?
My view is going to be a little bit different. First of all, this isn't a new idea by any means. When the last go-around of the ABA model rules was underway, and I believe that was in the 80s, there was actually a proposed rule that would have permitted passive investment in a law firm. It was voted down overwhelmingly in the House of Delegates and didn't resurface again until it came back to the attention of the American bar, and then eventually, I think, a lot of lawyers and bar associations throughout the United States in the recent concern and consideration of the idea of multidisciplinary practice. For those of you who don't know what multidisciplinary practice is, think of big 5 accounting firms acquiring yet one more professional service provider, namely a lawyer, so that they can do one-stop shopping. It's a little bit different than simply a law firm going practice. It's a combination of disciplines that offers professional services to clients. The issues that have surfaced there have brought back to the table the issue of whether or not it's a good idea to have non-deliverers of services, of legal services, in control of or involved with the provision of legal services to the public. And so one of the questions I think the group has to ask itself, putting aside for the moment the steel-eyed looking at this from purely a business standpoint, is what does that do to you as a lawyer? What does that do to your client? If you're representing large corporations, the Fortune 100, large world.coms and so on, who are relatively sophisticated, they know how to choose. But if you're not, what kinds of safeguards do you have to consider when you're setting up your firm that is now going to be a public firm? How do you protect the privilege? You're under scrutiny when you're a public company, but you have an obligation to keep your clients' confidences. Can you protect that in a public corporation situation? What about the duty of loyalty to the client? The fee-sharing rule, which is the ethical barrier right now, is always been phrased in terms of loyalty. Do you have divided loyalties? What about the independence of your judgment? We're all under pressure these days. We know what it's like, but nevertheless, is there yet one further pressure on independence? Those are some of the questions I think you really have to ask yourself as a practical matter. Would you like to be in that culture, and what could you do to preserve these, assuming you want to? Will the rules change? I don't know, but let me, before I pass it on here, mention something. We're behind the curve. New South Wales. New South Wales has proposed legislation that would not only permit lawyers to go public, but list on the stock exchange. Their proposed regulations would permit any corporation, not a law corporation or anything else, to include lawyers as part of the services they might sell or the products they might deliver. They don't have to be a law corporation. There are some restrictions. You have to have a solicitor on the board of directors. And there are some very interesting efforts to build in and address some of the questions I've raised. But maybe what you ought to do is think about setting up branches in Sydney, because they're going to be on the stock exchange where we will.
Interesting. First observation that I'd share is if you think about the question, should law firms go public, I'd begin with the observation that there are many different kinds of law firms. And there's some law firms for whom going public might be a much better idea and much more rational than others. And I think if we just look around, all of us in this room, and think about the firms for which we all practice, we will see the differences in the economics of our practice and the style of our practices very, very quickly. If you start at one extreme, the type of business that I might imagine might not be very exciting from a pure markets perspective, and let's assume that law firms can, as a technical legal matter, go public. Let's assume that it can be done. You take a straight dollar per hour billing kind of situation where there is no premium billing, there is no separate opportunity for investment. That is not a hugely scalable enterprise. I mean, where do you see the tremendous opportunity for earnings per share growth? It doesn't strike me that is the kind of situation that necessarily is a compelling stock market story from a buy-side perspective. At the other extreme, you have entrepreneurial class action attorneys who have to invest a large amount of money up front and really take an equity type risk the same way that a biotech company takes a risk. If you think about a class action litigation, it's an R&D project, all right? And if you want to raise capital for an R&D project, what you need to do is you need to share part of the profits in the event the new molecule actually turns out to be a great drug after 5 years of FDA testing, or if it actually survives the motions to dismiss and summary judgment, what have you. So the economic model, plaintiff side, class action litigation, biotech development, new .com company, it's pretty close, all right? So the issue then becomes, my question is, if you're going to see firms go public in some sequence of economic rationality, it would probably be the companies that have a real need for the risk capital and can pay back with multiples, all right, the same way that .coms and new biotech companies can in this kind of situation.
Besides the sweet irony of Milberg Weiss getting sued for securities fraud.
It is a new dimension to the word delicious. I understand. And then with the internecine behavior that goes on in many of these class action disputes, it's when, Barrick Rodos, it's also public, sues Milberg, and Milberg countersues because they were a shareholder in Barrick. So everything can and probably would happen in that environment. But what's interesting is if you think about the technical rules in terms of fee splitting and the like, and if you think about the demands for capital, as a practical matter, there are probably enough wealthy class action plaintiffs' lawyers in the country already to provide the necessary funding to anybody that wants to start up this kind of business without violating the rules on fee splitting with non-attorneys. So we now do have, as a practical matter, a venture capital class of legal entrepreneurs on the plaintiff side in the United States. And entry to that class, in effect, is limited by the ethical rules that say it's okay to share lawyer fees with other lawyers. Now you've got lawyers worth hundreds of millions of dollars because of the tobacco settlement. And there's no reason why, if I went into business doing class action plaintiffs work for whatever, I couldn't enter into a fee-splitting arrangement with one of the new tobacco billionaires, all right, and have them involved. And that's perfectly fine because they're honorable, because they're a lawyer, QED.
The opportunity for conflict challenges is really very interesting, and also the possibility of being the white knight. I actually thought about this about 20 years ago and really saw it in terms of takeover battle. But there are opportunities out there, and in fact, there are ways you can almost structure right now if you wanted to get there without actually going public in the classic sense. And I think you had some ideas about that, Craig, in terms of approaches. I don't know if this is
Going public, not in the classic sense. Well,
you had an idea of there might be a way to go public more or less right now under the rules, and I think...
the doctors do it. Yeah.
Well, we were approached, actually. Venture Law Group was approached about 2 years ago by a major underwriter, which had done quite a number of public offerings taking physician groups public, and they thought it was a possibility to take to carve out a specialty of starting to take law firms public, just like they had taken physician groups public, and thought that they could structure an arrangement with a holding corporation, with a legal professional corporation providing services to the holding corporation. I don't know if that really would have worked, though. I mean, that was the thought. We discussed it briefly, but we just weren't ready to even consider the possibility of going public at that point. But it was interesting that at least one major underwriter thought that it might be possible. Do you think, Joanne, would that work?
I have some doubts about that as a structure, because one of the difficulties you have is that ordinarily, because of the fee splitting rules, that really bans passive investment. And there are issues about aiding and abetting the practice of law. But there is another model that's actually being used now, not in the United States, outside the United States, but it may be being used in the United States as well. I don't know how many in the room have heard of McKee, Nelson, Ernst & Young. McKee, Nelson, Ernst & Young is a Washington, D.C. law firm. Its principals include Bill McKee and I think Mr. Nelson, both of whom are well-known names in the tax area, who left prominent national law firms to set up this new law firm, which will be a full-service firm, not simply a tax firm. But peculiarly enough, it has the name Ernst & Young attached to it, because Ernst & Young has no equity interest. I've been told that by several people in EY and outside, but apparently has some sort of arrangement, debt, in which it is funding this new law firm, and has some other arrangements, presumably with respect to generation of clients and so on. I don't know what the rest of the structure is, because nobody knows. It's private. But in Canada, I do know that Ernst & Young also, you might say, owns a law firm in quotes. And what they have done is as follows. The law firm in Canada is owned entirely by lawyers. It has arrangements with Ernst & Young. Again, Ernst & Young Canada has no equity interest, but every principal in the law firm owns a piece of Ernst & Young Canada. So if you can start thinking of the structure that way, you're not public, but you're part of a public company. But that doesn't really get you where you want, or where I think other people want to be, which is sort of the idea of the independent law firm, Wilson, Sonsini, Skadden, whomever, going public as a standalone operation. I don't think you can do that right now. Whether you'll be able to do that in the not too distant future, I don't know. A lot will depend upon what rules get changed or what challenges arise to the rules.
Let's assume you decided that going public was a good idea, was something you wanted to try. What would you do with the money? I mean, what are some of the creative things that you might do with the money that right now, under the typical law firm structure, you feel you cannot do or don't have the funds to do?
Well, one thing to remember, of course, unlike a .com, you would be required by the market to have earnings. So you couldn't take the money and pay it to people, right? I mean because that would be an expense, and you would wipe out your profits. So I mean that's sort of public offering 101, right? The use of proceeds is normally, if it's a profit-making enterprise, the use of proceeds is supposed to be something that doesn't go through the income statement, at least not right away. That I think kind of constrains you to some degree, but you look at capital things. I mean, in terms of, I mentioned tenant improvements. Craig, you've thought about technology, I know, as being a...
Well, would you, Alan, what would, you have such great investment opportunities at Wilson Sonsini. Would you consider increasing your investment program through WS if you had more capital?
Unlike VLG, we don't have... Well, that's an interesting. I mean, if you think of the law of the offering being by something that's a law firm but has another business, an ancillary business, so that really, in part, you're taking the law firm public, and in part, you're taking this other business public, whatever that is. And there are a lot of law firms around the country, I'm told, that do a variety of other things. They have consulting firms, or some have big investment management functions, and so on. We have a venture fund. Most of the firms in Silicon Valley do. Yeah, I suppose conceivably that would be something you could do. You could raise money, and then you could put more of it to work and essentially be a bigger investor in companies. You'd be competing with your clients who are in the business of being venture capital investors. We sort of get away with doing this on a very small scale without the real VCs minding too much. I think if we had millions and millions of dollars and we were essentially competing with them, it would change the dynamic. But that's conceivable. There would be. We got a securities law professor over here, though. There would be some legal issues because we might have to register as an investment company, and I don't think you could run a law firm as a registered investment company very well.
Yeah, it could be a problem. In fact, we're having a conversation at the table before this panel. There'd be a serious issue as to whether, if the investment fund was big enough, it would, as a practical matter, suck you into the definition of the Investment Company Act, which would then give rise to all sorts of constraints on internal operations and the like that could really make the functioning both of the portfolio and of the law firm extraordinarily problematic. There's several exemptions from the Investment Company Act, but there is no exemption that I'm aware of for the practice of law. And since you wouldn't be actively engaged in the operation of most of these businesses, it would be one of these inadvertent situations. Maybe you could go and you could get an order out of the SEC, and I could imagine making a reasonable case along those lines. But it's yet another issue that would have to be massaged before you could do a public offering.
Untrammeled as I am by any knowledge of the securities laws, I am a tax lawyer. I guess that's the right to say in this company. A couple of things I would think about. One, we haven't really begun to see the true globalization of law practice, except, I guess, in the eyes of Clifford Chance, Rogers and Wells, and whatever the name of the German firm they've got. But I could go out and see buying some firms around the world, so I could truly globalize my practice, and I sure need a lot of money for whatever infrastructure I would need in that particular regard. So I think if you think about the practice as globalization and the need for looking forward, and the fact that you could stay here and practice instantly any place, because who knows where you are in e-commerce, I could see the need for a lot of capital in that regard. The other thing I would toss out, which is completely off the map, but it's starting to get talked about, is suppose you decided to commoditize certain types of practice. I agree with you in terms of the bang for the buck. Something like a big contingent fee plaintiff's firm really looks pretty good. Or once in a while, if you get on the ground floor of some of the tech stuff. But what about giving advice over the internet, which is already occurring right now? I think we all thought years ago, they used to say that, well, heck, nobody will ever give up brokers because you need the advice. And everybody trades over the internet these days. What about delivering law over the internet. There are already advice firms on the internet right now. And what you can do is you can sign up and you can get some of your information, and you have your network throughout the world, throughout the United States or various other places, I suppose, throughout the world. So if I wanted to set that up, I'd sure need capital.
I mean, the issue, I think, really is, if there's one place that is a screaming need for capital, it is technology. Let's look at the productivity of the legal business. It stinks. Okay. I mean, how have we scaled ourselves as lawyers? How have we managed to increase our productivity per hour? Look at the model that we use for even for billing. Billing, per hour. We haven't figured out how people have talked about value billing for who the hell knows how long, and very few people have really figured out about how to do it. I mean, look at the increases in computing power. Look at the increases in pharmaceutical efficacy. Look at the increase in the quality of automobiles. We should be ashamed of ourselves, given everything else that's happening. And part of the reason for that, I think, really is nobody has really looked at technology as a tool to really increase legal productivity, and nobody has cracked that nut.
Well, we've tried, to see what we could do to carve out of our economics enough money to do some degree of R&D spending. Our R&D attorney is here tonight, and Linda DeMellis is our effort, along with another transactions person where we're trying to take lawyers and prohibit them from billing to clients just to develop better tools for other lawyers. But the problem you have is that there are limitations within the current economics of putting aside money to do this. Many companies spend up to 10% of revenues on R&D, but law firms traditionally haven't. And it's been pretty obvious that law firms have lagged in terms of innovation and tools. And I think, frankly, that was one of the applications I first thought of. I thought it would be very interesting to see what you could do if you could retain half your earnings. Can you imagine what Wilson Sonsini could do with an extra $50 million? I mean, now, granted, you couldn't spend all of that without destroying earnings, but I bet if you really had that money to spend, you'd consider some projects you might otherwise not have considered.
Again, assuming a law firm IPO would be possible, would you be concerned that investors' pressure to improve earnings would cause lawyers to compromise their clients' interests, or do you think lawyers would act professionally and resist that pressure?
You mean compromise client interests more than they already do, or?
You can say that, I won't.
I just want to know what the question is.
You think we're accounting firms or something? It's sort of an intro. That's a real question. And I think it is a real question in the sense that much of the debate right now is floating around that question. We have had the basic rule that prevents you from doing what we've been discussing, the rule of fee splitting there, as a protection against divided loyalties. And although there is a discussion about how shareholders outside shareholders really have absolutely nothing to do about the running of the firm, let me toss out a model that troubles me quite a bit, and sort of hold that up. And that was, I think, what you were talking about earlier, Craig, with the idea of using the physician's model, where physicians sold their practices to a payor, and the payor, to some extent, now decides what kind of medical service you get. Do you really like going to your doctor these days? Do you think that the medical profession has been improved by the type of managed care that is now prevalent no matter where you look? Do you think the doctors like it? Do you think the doctors made any money? I think the answer on that one is no. People have not made money. Certainly patients are very concerned about the quality of care that they get, and we all have horror stories about that. And I'm not even sure the groups that put these little packages together are doing well. So that's, if you look at it from a purely selfish standpoint, gee, we're going to make money, we'll all go public, and we all have options, we're all going to cash in. I think there may be a practical maybe about that one, but on the other side, and I think we have an obligation, we are professionals, whether we like it or not. Most of us are very proud of being lawyers. Most of us feel that we're sort of special in a particular way. And one of the questions I think we have to ask ourselves is this really going to be good for our clients? And we've talked a lot about what we could do with the money, but does this, I think there's a basic issue here. Will this improve the service that we can give to our clients? And that's the question I toss out to the rest of the panel. Do you think having all this extra money means that we're going to improve service?
I think I'm agnostic on the issue. I could actually see how it could go one way or the other. And I think the important thing to recognize about the current state of affairs are the vast number of conflicts that already influence the practice of law, even without the additional conflicts that people think they would see from public ownership. I could actually see how the addition of capital might actually reduce certain types of conflicts, improve the quality of practice, allow people to make investments in longer-term thinking and longer-term representation. And I could make a credible case that it would actually improve the quality of care for clients. You could also turn it around and say that there'll be a phenomenon of, short-termism, as some people suggest exists at many Silicon Valley companies, that arguably might make it worse for clients. I personally can't figure out how to make a clear prediction along those lines.
One thing that is different when you compare law to medicine is that in medicine, the patient is always a person. Many of our patients are much bigger, really big persons, Cisco systems, right, or whatever. And of course, they're self-insured, right? They're not. They're what the kind of legal services they buy are not a function of their insurance carrier. They can afford to pay what they need to pay to get what they want in terms of service. So I don't know that we'd ever be in a situation where Cisco Systems is in an HMO of legal service and can't get out. I think they'd find a way. But maybe in a way that misses the point, because what about the people who are just people or who are small business people or whatnot and wouldn't have that kind of leverage and would possibly be stuck? I think that's a legitimate concern. I also think that in a way maybe we're a little naive in our mental image of what this would be like. I mean, we all think, I suppose, of, just the same law firms that there are now, except they'd be public or whatever. Whereas presumably that would only be the first wave. I mean, the second wave would be much larger agglomerations, probably at some point insurance companies, banks, very, very large financial institutions would wind up buying the law firms if they were publicly traded. And so then legal services would be delivered by very, very large institutions. And presumably there would be boutiques who still did the real high-end things. There'd be room for Goldman Sachs of the legal profession or whatever, as well as maybe some smaller ones. But I think that the jury would really be out on whether in the end the average consumer of legal services would be better off getting them from a very large institution like that as opposed to getting them from a small owner-operated business.
I would take a slightly different point of view than that, because I generally feel that better access to capital would improve client service. I think one of the big problems is that entry into the law firm business is relatively restricted because access to capital is fairly difficult. I know when we started Venture Law Group, we didn't have access to venture capitalists or any kind of additional funding in getting started. We had to fund it all out of our own pockets. And obviously, if that's one of the requirements of getting into the law business, you're not going to have as many companies trying to be innovative and get started, because it's a lot harder to fund things. It's a little bit like the way they do technology companies in Europe, where for a long time there wasn't a venture capital market, and the only way a founder could get a company started was to take on bank loans. And so I think actually I could make a pretty good argument that if there was better access to capital, you wouldn't end up with a whole bunch of massive, huge organizations providing legal services, but you might actually encourage a lot of smaller, innovative law firms to get started, because there would be a way to bankroll them other than out of the pockets of the founders.
I would suggest that that might be naive. And the reason I would suggest it's naive is that if it is going to be successful in terms of what we will call the high end of the practice, it will not stay independent. Because if you have a rule, if you change the rules to permit sufficient passive investment to allow law firms to go public, there is nothing to prevent larger institutions to do exactly what the larger institutions are doing right now outside the United States. At the moment, the larger institution happens to be the Big Five. The Big Five is small, and the really large institutions have not surfaced. I will point out to you, if you don't know already, that Blockbuster Video owns Century Business Systems, which has been gobbling up middle-sized accounting firms, and that American Express is either the 7th or the 8th largest accounting firm in the world. When you start opening up the ownership, I don't think law firms would stay owned by lawyers unless the rule were only lawyers in I think the particular VenCap firm you suggested, owned all by rich plaintiffs' personal injury, and now other type lawyers could go in and buy other law firms. So I think what you are looking at if you do this is a different kind of practice and possibly a different kind of profession. Now, that doesn't mean you shouldn't think about it. But I think we ought to think very clearly what that will mean, and if and what the effect will be on what it is to be a lawyer, especially since we don't exist in a vacuum. We are officers of the court. We are controlled by the courts. People forget that because I think many of the people in the room are probably on the business side and don't get much into court. But ultimately, it is the courts that decide what we do and how we do it and when we do it. And you have to stop for a minute and think that if you're in a different context, will that be the same? Having said that, I would also point out that for many, we're already in a different context. There are people who are inside counsel. They're in corporations, although they have only one client. There are third-party funding arrangements all over the place. Insurance companies now in many states will use inside counsel to represent insureds. That's about as close as you're getting to the practice of law by corporations right now. Outside the United States, many law firms are already part of larger business institutions. So maybe the change has already come. But I think you have to put everything, including going public, in that kind of context. And as I say, I think we ought to think about it. I think that's what's important. To do nothing is the worst. So I think this is a terrific opportunity to begin to consider this.
Someone touched on this earlier, but I think it's worth going through the mechanics of how you would value a law firm. And Craig, I know you've thought about that. Maybe you could go through the calculus.
Well, when we had our brief discussions with this underwriting firm, they tried to find some comparable models, and frankly, it was hard to find too many companies that were too on point. One that was pretty close in the non-legal profession was a company called Law and Economics Consulting Group, LACG. That was a group of PhD economists that provided expert witness testimony, and actually the economics of LACG, which did go public, I think it was one of Mario's clients, I believe it was, were very, very comparable to that of a law firm, because you had professionals who were billing at very much the same kind of rates as lawyers on an hourly basis. And if you looked at the financial statements as we did, and the P&L, it looked pretty much like what you would have expected from a top tier law firm. But actually, it was interesting that the market, at least at that time, this was several years ago, didn't really value a business like that, very highly. I mean, it was, the estimates were, 10 times trailing earnings or something like that, maybe a little higher. But again, a service business, I think, was discounted to a significant extent because I think investors were skeptical that it could scale, that you could replicate easily. I mean, growth was considered to be relatively slow when you think about how law firms grow. You have to accrete skilled professionals. You have to train them. And you don't have the kind of intoxicating images of hyperbolic growth that you do with some of the companies that you see out there. I mean, we're a pretty staid profession, and, it's taken great firms like Wilson Sonsini 30 or 40 years to grow to where they are today. And now the market wants instant gratification where everything happens in 12 months. It's kind of hard to grow a law firm to billions and billions of sales in 12 months or 24 months. So the problem, I think, one of the observations we had is, would it be all that interesting? I mean, would you end up going public and then having an $8 stock, and you have the worst of both worlds? You've given up half your earnings, and you have a security that's largely underwater. So, I mean, valuation was really problematic. It was very hard to see how you could be a real superstar stock.
Yeah, I sort of looked at it from the same. I looked at it from the same perspective, and what would be in it? What would the market value? Clearly, LECG was a close comparable. It was since acquired by the Metzler Group, which was then acquired by Navigant, and I'm not sure what that means, except perhaps to support the theory that it's just one fish going to be gobbling up another in that environment that way. If we go back to the PPO and the medical care analogies, which also have some attraction. It's valuable to observe that those are some of the worst performing stocks that we've seen in the U.S. capital markets over the last several years. So to the extent that that's an analog, I would suggest that it's perhaps a morality tale in terms of what not to do rather than what to do. And then there are a small number of consulting type organizations of which I'm aware that are doing very well in the capital markets now. But they have scalability features that law firms, that I haven't figured out how law firms can replicate. Here I'm thinking about the Science, the Viance, the internet-based consulting firms that are helping companies build out their internet sites. They wind up getting paid very high rates. They've got huge rates of growth, and they also wind up picking up equity in their companies, in the companies for which they're consulting. So there's a very interesting model. And then there's a small set of consulting firms like the Gartner Group or what have you. But they went through a rough patch till they figured out that what they needed to do was focus on consulting projects that could scale, in the sense of you get a small group of analysts, they work really hard, they produce a report, and the report then gets sold for $20,000 to 80 different clients, and it's the marginal cost phenomenon. It's like you're in the record business. Fixed cost of production is high, marginal cost is low, but you sell it at a fairly high price, and that's a business that some people have figured out how to scale too. So if you look at all of the comparables and you try to define them as broadly as possible, I still have a hard time making the economics work.
That goes back to what I was concerned about. The partners who were there at the time you do it make a lot of money, but how does it really work going forward? You've got this stock that may not be such a strong performer, and you've given up half your earnings, and you've got these stock options that are kind of lackluster. That firm, I think, would get whipped pretty badly by one that had stayed private and could still offer 100% of the earnings.
But Alan, I'd like to challenge that in one sense. What do you think? Goldman Sachs went public after 30 years worth of discussions. Wouldn't that same analysis apply to Goldman Sachs and the new service providers, or is there a different issue?
No, if you look through Goldman's balance sheet, let me tell you, they needed the capital. They've got a proprietary trading desk. You give them a ton of money, and they'll make another ton of money, and they'll still need a third ton of money with which to make a fourth ton of money. The business at Goldman is taking IQ points, applying them to large pools of capital, so as to create even larger pools of capital. The type of leverage that's at work in that kind of business is I think fundamentally different from what we as lawyers do as lawyers. Capital is not a means of production for a law firm. Capital is a means of production for Goldman Sachs. It's like clay to a sculptor.
I was going to say, this might be a good moment to take some questions from the audience.
Yeah, just building on that last point. Capital as a means of production, enhancer production, productivity for law firms. I'm curious about your take on deployment of capital expenditures for technology with respect to one specific area. Visual collaboration, video conferencing, broadband and streaming media are going to ramp up substantially for the next 5 to 7 years. And we'll be at a point relatively soon where the broadband bandwidth connections that are being built out there will allow consultants, lawyers, doctors to provide service consulting and scale in a way that they've never been able to do before. And I'm curious about, number one, your thoughts on that technological advance which is unfolding. Number two, how that affects the viability of going public and going global.
That's right. Go ahead.
I think you're absolutely right in terms of your prediction, and let me just draw an analogy to current business practice. I can't think of more active users of telephone service than law firms. But that doesn't mean that law firms should go into the switching business or should become telephone companies. I think you're absolutely right. The technology is going to evolve, but the optimal providers of that technology may well not be law firms or lawyers. You could certainly imagine that would allow more branch offices to exist if it were easier to communicate, if you felt that you could be closer to your partners because video conferencing was that much cheaper and what have you. But in terms of affecting the underlying dynamics of going public, I'm not sure I understand what the effect would be.
Well, you may be talking about the whole nature of the way services are delivered has changed. I got to tell you, I hear it, but I don't understand it. I can't visualize how it's going to change. Maybe that's just my fault, but I'm sure that if we were having this meeting 3 or 4 or 5 years from now, and some of those issues had become more clear, the implications for the way law firms are run, the way they finance themselves, would be more clear. But boy, I just that looking glass is just too dark for me to see into right now.
One thing it might do, and it can't be done right now, but it's another issue. It might change very much the dynamics of where and how you practice, and it might make a difference in what the law firm is. It isn't even a question of being close. If you stop to think that video conferencing and so on is really a form of presence, and the kinds of things that you right now do that require presence. And again, I think most of the people in the room are on the business side, but think for a moment about the litigation side or the hearing side, where you really wouldn't have to go someplace to appear. You would appear technologically or virtually or however else you wanted to describe it. When you stop to begin to think about that, I mean, where are you practicing law? The little baronies that we are, the 50 states plus the District of Columbia, I think would have to fall. And the view of the law firm or the size of a law firm or where a law firm is, I think would change radically. And that might again drive the need for capital to permit the setting up of the technology. So it's an unclear vision, but I think the social dynamics change, and that might make a considerable difference 10 years from now, not only in what we do privately, but what is going to be done publicly. And I think we may have to adapt there.
Another question? Jim?
Alan and Joe both alluded to the idea of how going public might change the internal culture of a law firm. Joe, for example, alluded to the idea of the Gartner Group, producing one report and then selling it 80 different times. Why can't a law firm do that? The standard off-the-shelf option plan, for example. And then, in addition, with respect to the internal culture of the firm, do you think this would change, for example, the now standard partner-associate makeup and create a structure more like investment banks? And you might have put pressure on the 7-year partnership track. And if so, is that something that might happen anyway?
Should I repeat the question, or did people hear that?
Repeat it.
Repeat it, okay. I'll try to condense it. I think basically Jim was asking whether, similar to what the Gartner Group did, if the prospect of having this extra capital available would change the sort of products that lawyers produce, and also whether it might change the internal hierarchies of law firms, a sort of partner-associate structure.
I have an answer to that. what I think is starting to happen with law firms is that they're finding other ways to monetize their intellectual knowledge, their knowledge, other than just delivering hourly services to clients. And just like the Gartner Group can produce the same report and sell it 80 times for $20,000, law firms are becoming more creative in finding other ways of commercially exploiting their knowledge. I mean, a good example is the subsidiary set up by Littler Mendelsohn Employment Law Training, which is a firm which is a for-profit, non-law firm subsidiary of Littler Mendelsohn, which they intend to take public, providing legal education, legal training to large corporations, and potentially could be quite a big business and quite a very valuable asset to the law firm. Now that's clearly a law-related business, and it certainly benefits from Littler's expertise. But in a way, it's almost like a reverse IPO. The lawyers get to stay collegial and within a firm, and yet by finding a different vehicle, which also could use capital, because I mean, if you're starting a business like that, you need to raise capital, whether it be through venture capitalists or from your own organization. But it gives you the ability to monetize your intellectual knowledge in a way that completely circumvents the current prohibitions on law firms going public. So I think it provides, I think in some ways maybe law firms are beginning to invent around some of the restrictions and some of the problems that currently exist.
On the second one about changing culture of law firms, yeah, I could well imagine. I mean, let's face it, why are law firms organized the way they are? I mean, if we had it to do over again, wouldn't we do something different? I mean, why this sort of up or out thing, and the sort of partners and the associates and so on? I can well imagine that a publicly traded law firm where the secretaries had stock options and the associates had stock options and so on. What does it mean then to be a partner at that point? I mean, it would just be a series of titles, presumably, that would exist within the organization, and I think that's probably a plus. I mean, I think on balance that would be one of the good things about such a change. Is it would cause a rethinking of that traditional model, which is, in the absence of something to cause it, is a very difficult thing to change. There's a tremendous amount of inertia behind firms being organized the way they are. It's tough to redo it.
Another question? Let's see. Way in the back there. Yeah.
Just a question similar to Ask Jeeves, where it's a real word search engine. Is that a possibility where a database, I know some medical sites are creating this kind of activity where you can basically key in certain questions and you'll get some prompts, and ultimately you'll get maybe a diagnostic for a cold or certain medicines. Can you do that? That's a way of commoditizing practicing law. I think, in fact, Littler Mendelsohn had a program where they were doing something like they constructed a very large database, and there wouldn't be a real person talking to you. You'd submit some questions and get back some pretty standard responses, which were very, very much on point. So is this a way you could commoditize the practice via the
Well, there are a bunch of initiatives that have been around for a long, long time. They harken back to two words that caused venture capitalists to lose tons of money in the 1980s. It's artificial intelligence. And one can very easily imagine taking legal rules and legal principles and boiling them down to flow charts. And I do this for my students all the time. I mean, I'll take Reg D and I'll make a flow chart out of Reg D. I'll take the Holden versus Agopian test for whether a general partnership is a security or isn't a security, and I'll reduce it to a flow chart.
Does that mean your intelligence is artificial, Joe?
Well, no. Well, first of all, as a litigator, I might say assumes a fact, not an evidence. And because what's really intriguing to me as I draw up these flow charts, which take Ninth Circuit principles and say, well, okay, the first thing you got to do is examine this. Is it yes or is it no? If it's no, you go to a different test. You examine this other thing. If it's yes, you then examine a third different thing. It does two things at the same time. Number one, it makes clear what the issues are. And number two, it makes clear that the art form is in knowing whether the answer is yes or no. All right? Because, in a certain and often very large percentage of the cases, the answer will be clear. But the real value add that a lawyer provides is understanding that there's a certain subtlety hidden in the question as applied to these facts that lets you answer this decision box no rather than yes, even though at first glance you might say yes. And it's that level of art which artificial intelligence was insufficiently able to capture in many other areas that I still haven't figured out how to reflect in all of these flowcharts. And if you think about what you'd have to code in order to make this work, that's all of the code eventually boils down to a decision tree type of analysis. And at some point, there's an element of human judgment you don't catch. There are going to be some areas under tax law, for example, where it's pretty crisp. All right, you apply a percentage test, and there you are. So you're out of work before I'm out of work.
No, my first question is, what do you want the answer to be? Actually, there are simplistic variations in existence right now. One area with respect to, and when you mentioned the flow chart, it made me think of this. A problem, and not on the high end of the practice, but in areas like family law, that has been a growing problem, is the inability of people to be able to afford lawyers. And the effect of this has been to release into the court system, not so much in California, but in other states, a flood of pro per litigants primarily in the family law area. In Arizona, for example, about 90 to 95% of the people in the system, by the time they have gotten through part of the system, are by that time representing themselves. And so what the court system in Arizona has done is create those types of things in sort of self-help kinds of arrangements in which people literally go and they sit at a computer and they punch in, they do their forms, they do the stuff. You can go up to a kiosk in a supermarket and get a divorce in Arizona if you do it right. So that's a real possibility. That's on one level. Another thing that is already out, I haven't gone up on the site, so I don't know what is actually there, is something like this, the legal services self-help. It's more in the nature of a chat room kind of arrangement where, you type in and then you go away and somebody else, an attorney comes on and types in, and you can start that kind of an electronic dialogue. Those are starting in. There were some of these self-help sophisticated things. I think Quicken had one in Texas. The Texas court said that was the practice of law and said you couldn't do that anymore. And what happened is the kind of thing I think you will see happen is the Texas legislature amended the law and said it wasn't the practice of law. So that's now alive and well in Texas. So if you can put it in a book, if you could do it in a series of questions, if it's simple, the answer is yeah, you can commoditize it, and I think that's already happening.
Take one more question. Okay, we'll take one more question. Or none.
Assuming accounting firms are allowed to practice law, and you can set up a firm with accountants, lawyers, economists, technology experts to serve as expert witnesses, that firm can take equity positions in clients, and assuming we have a full-service advisor company, does that change the way you analyze whether or not it's to that company's advantage to go public, or that firm's advantage to go public? We're providing not only legal services, but a full range of advice services to primarily corporations and wealthy individuals.
I guess I would say it would probably take a lot of capital to put something like that together, so there'd be an incentive to raise money to do it. If you're and you certainly would have departed from the traditional law firm model, so you'd already be in kind of a more traditional company kind of model, which would lend itself well. But I suppose you'd still come back to this question of, would you be a lackluster stock, or would you be able, through that kind of combination of services and so on, to do more sort of value pricing or whatever, so that you're commanding bigger profits, and then maybe it would be more attractive as an investment. I'm just trying to. I haven't thought about it a lot, but I'm just trying to answer kind of off the top of my head.
I think working off of Alan's observation, the question is, okay, so you've got this multidisciplinary team of people. The issue then becomes, what are they doing? You can find analogies, for example, Bill Gross's Idea Lab. All right, to the extent that Gross has built an incubator, he's got in-house counsel that provide legal services to the startup companies he's trying to incubate. He's got technologists that help them along. He's got accountants in there that help them with books and records. So he's trying to create a shareable infrastructure around which other people can build out product-specific types of ideas. And if he's able to go public at the multiples that people are talking about, exactly the kind of team that you're discussing is going to be monetized for a value in the many billions of dollars, but not just because it's that type of team. It's what has the team been doing. If you also look, for example, at GE Capital. GE Capital, if you look at the nature of the skill set that's behind the company, again, is very similar to the type of organization that you've been talking about. But their value add comes as a function of what it is that they would do. If it's the provision of advice without a clear articulation of how that advice is going to add value in a way that can be captured by the shareholders, then I'm with Alan. It's very tough to understand where it goes. But if what you do is productize that set of human abilities, and you say, well, okay, we're going to incubate startups, or we're going to do the kinds of things that GE Capital does, or we're going to do Goldman Sachs, they got lots of lawyers working in there. It's just that they're not, they're ARBs, the same way that Rubin used to be an ARB. All right, Yale Law School grad goes off and becomes a risk ARB. There are other ways to lever human capital other than dollar per hour billing arrangements.
All right.
Well, thank you. And thanks to all our panelists.